And then I'll look for
All
the
right.
brother's name, which is
Good
Loyola.
afternoon. This is Judge Elisa Bettis presiding over the 210th District Court criminal docket for April 30th, 2024. All matters being heard today are being heard in accordance with all emergency orders and directives regarding remote proceedings. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Monares, would you call our first case, please?
Calling cause number 2023-0D01180, State of Texas versus Ernesto Perez Hernandez. May I have announcements, please?
Ada Warner for the state of Texas, present ready.
Rick Huffman on behalf of Mr. Perez, we're ready.
And I believe he also has 2024-0D01751. Is that your client appearing from the jail annex, Mr. Huffman?
Yes, Your Honor.
Okay. And is he set up with the interpreter already?
She's here, Judge. I'm setting it up.
Okay.
I apologize, Judge. I'm unaware.
No worries, just let us get started. All right, attorneys, if you would select English, please. And then annex if you'll select Spanish. Are we squared away?
Hey.
Mr. Huffman, Ms. Winery, are you on this one?
Yes, Your Honor.
Yes, Your Honor.
Ms. Winery, if you'll select English, here.
Where do I select English?
Interpretation.
Okay, gotcha.
Correct, on the interpretation function at the bottom of the screen. Are you there, Ms. Winery?
Yes, Your Honor.
Oh, perfect. Okay. So for purposes of the record, Mr. Bettis is appearing remotely from the jail annex and is utilizing the assistance of a court interpreter, Ms. Gloria Noyola. We are scheduled in the 2023 case for a pre-revocation hearing. In the 2024 case, we're set for arraignment. Mr. Bettis picked up an ag assault deadly weapon, which is our 2024 case. He also has a misdemeanor criminal mischief. The recommendation from probation is, of course, to screen for intensive supervision. I know we're only at arraignment, Ms. Winery, but do you already know what the rec is on the 2024 case?
No, Your Honor. I was going to wait for the revo to see how that proceeded and then try to make it to where they're tangent. They're kind of concurrent.
Well, I think it's, I mean, I don't have a lot of he was on 2 years deferred as of November. He was explained his conditions. He started doing some community service, negative UA, but I don't have much in terms of his probation. So I need to know how strong your cases are, because obviously I'm not looking to keep him on probation. Looks like we have a motion to adjudicate filed April 15th. I'm not looking to keep him on probation if if your rec is time or anything like that, but
Okay.
what's the ag assault allegedly?
He went to sell a car battery at a dealership. The dealership stated that they couldn't take the battery, so he chased the salesman through the parking lot with a screwdriver.
Mr. Huffman, what do you have for me?
Well, Judge, my client does deny that. It's quite the contrary. He was the one that was attacked. We do have some video kind of showing the aftermath of what happened when they were basically following him out into the parking lot. It was multiple people that were attacking him. There's, from what I can tell, no surveillance footage inside the actual dealership, which is odd. I mean, I kind of question that. So I've sent my investigator a request to go take pictures of the dealership and any cameras, because it just doesn't make sense. My client's going there to sell property, not to go assault anybody. He doesn't know these people. And he was one that was attacked. So we are definitely contesting these allegations, Judge.
He has his jury trial set for December. For now, I'm going to carry the probation case with his new ag assault.
And Your Honor, I will review what I have with Mr. Perez, and I assume we are going to file a motion for a bond hearing pretty soon, Judge.
Does he have a nice hold?
Your Honor, if I may, that's what I wanted to see if I will please let the court know. There is a notation in the case summary I received, and I did check the jail menu, and it does appear that there is an ice hold.
Alrighty, thank you. Okay, we'll go to our next setting. Thank you, Mr. Bettis. Does anyone else need the interpreter, Mr. Monares?
No, Judge, that was it.
Ms. Noyola, thank you very much.
Okay, Judge, page 16, Hernandez Josue. Annex, can we have Hernandez Josue, please?
Yeah, it's coming up.
Mr. Trochet?
Good afternoon, Your Honor.
Let's go ahead and turn off the function, please, the interpreter function.
Calling cause number 2024-0D-00323 and 2024
Mr. Monares, can we turn off the interpreter function?
It's off, Judge. Okay.
Alrighty. Go ahead and call it, please.
Calling cause number 2024-0D-00323 and 2024 0D-00233. State of Texas versus Hernandez Josue. May I have announcements, please?
Jacob Reynolds for the state of Texas, ready to proceed, Your Honor.
Jose Trochet, on behalf of Mr. Josue Hernandez, we are ready, Your Honor.
And Mr. Trochet, do you see your client appearing from the jail annex?
I do, Your Honor.
Okay, we're set for bond hearings in each of these cases. I show, let me see, is it 30,000 on the drug case and the unauthorized use is 2,500. You may proceed.
Thank you. Your Honor, my client's been in jail now for some 90 days, or if my recollection is correct. I have talked to his family. I did receive a rec here. We're dealing with the prosecutors, normal prosecutors in your court. Not that Mr. Mr. Reynolds is abnormal, but he just came on the case relatively recently, became a border protection case. He did give me a rec of 7 TDCJ, which I conveyed to my client. The clients rejected that, of course. So, Your Honor, we are hoping to get a bond that he can meet. I talked to his family. They are able to come up with maybe $300 to $500, for a bondsman and have someone sign for Mr. Hernandez. But that's where we are right now. He's been in jail for a long time, has not been able to be released. And obviously, we'd like to continue negotiations if we could on a reasonable plea in this case.
Okay, and Ms. Welch is informing me we also have another cause number for him, 2024 0D01690. And they do all appear, although, no, it is also set for a bond hearing. I'm not sure why I'm not seeing it on the ticket. And there, his bond is $1,500. All right. Anything, I'm sorry, Mr. Trochet, I didn't cut you off, did I?
No, not at all, Your Honor.
Okay.
That's really what I have, all I have today, Your Honor.
Okay, Mr. Reynolds?
Judge, we believe the bond is reasonable as currently set. Due to the nature of the offenses here involving both drugs and the use of firearm by a convicted felon, as well as stealing the vehicle that he was caught in. We believe he poses a risk to the community. There's also the fact that Mr. Hernandez has a pretty extensive criminal history. And I believe we've gotten certified copies of his prior pen packets and judgments uploaded to portal for Mr. Trochet's review. One of his priors is from 2018. That was bringing in and harboring aliens, a federal offense. He was placed on bail supervision for 5 years, although that was showing as unsuccessfully terminated. And he ultimately did some time in federal prison for that. And that was as recent as 2018. He also has several other arrests for smuggling aliens, probation violations in 2019, as well as several iterations of his federal supervised release being revoked, kind of going in and out of the federal penitentiary through 2019 and 2020. And it looks like he also has probation violations on state cases out of Otero County, New Mexico, involving the possession of a controlled substance, which is, for the court's reference, similar to the offenses we see here. I'm looking at an arrest in September of 2020 in Otero County for that. And then further possession of a controlled substance charges in 2022 in Otero County and Alamogordo. It's the state's position that based on his criminal history, he poses a flight risk and is a poor candidate for PR bond. So we would urge the court to deny the defense's motion and leave the bond as currently set.
Anything else, Mr. Trochet?
Yeah, he would be the only flight he would go would be New Mexico, and that's not very far. But anyway, I have spoken to his family. They're willing to help him, willing to come up with some money for him, and also sign whatever bond the judge would set in this case, or the bondman would set. So I don't believe, Your Honor, he would be willing to, I'm sure he would be willing to face his charges and then come up with some sort of reasonable plea in this case, Your Honor.
Thank you. Is there a rec?
The rec is 7 years TDC, Your Honor, although it sounds to me like Mr. Trochet said earlier, the defendant has declined that rec, so I think we'll be moving forward to the trial setting in this case with no further offers.
Okay, so our jury trial isn't until October. I did review the PSR. I'm not sure that this I don't know if I need to mention this, but is this the one we had some difficulty, Mr. Monares, with the identifiers? When we initially ran the PSR on this individual, it came back as a Joseph Hernandez. And then we used some other identifiers, and I think we got the right one. And that conforms with what you've presented to the court. I'm showing Indiana FFJ drug charges in 2016, 2018, the federal charges, which included maybe some type of illegal entry, but transporting individuals, unsuccessful, did receive time there. 2021, 2022, 2019, Olive Otero and Diana drugs, several drug card charges, contempt, failures to appear, probation violations. In 2019, 21, and 2022 was all the same. And then I also saw some entries in Maricopa in Arizona for drug possession. It looks like, if I can read my writing, that says 2014, but don't hold it. So in my opinion, the bond is adequate. Your request to reduce is denied. Yeah, that's it.
Your Honor, just real quickly, the next setting that we have is not till October, is that correct?
No, our jury trial is in October. Our judges conference is May 30th. Your 2801s are June 27th.
Okay.
And then it's almost monthly up until the trial setting. Okay.
And even though the recommendation does not state, I presume, Mr. Reynolds, that we need to accept that before May 30th, is that correct?
You said that he declined it.
Well, he and I talked about it. He wanted me to negotiate some more. That's not exactly a decline.
Okay, well, I think the expiration date on the recommendations tab is June 10th. I'll hold it open until June 10th.
I'm sorry?
I'll hold it open until June 10th, sir.
June 10th. Okay, thank you.
Thank you very much. You're excused, Mr. Troche, unless you have something else.
Nothing further, Your Honor. Thank you.
Thank you. Thank you, Mr. Hernandez. Who's next?
Next one is also on page 16, Judge. Hugendorn.
Ms. Hugendorn? Mr. Montes?
Good afternoon, Your Honor.
How are you?
Good, thank you.
Annex, can we have Hugendorn? Calling cause number 2021-0D02928, State of Texas versus Kim Hugendorn. May I have announcements, please?
Ada Winary for the state of Texas, present, ready.
Jose Montes for Mrs. Hugendorn, ready, Your Honor.
And is that your client appearing from the jail annex, Mr. Montes?
She is, Your Honor.
Okay, so we have this case set for a probation status hearing. If memory serves, she's got some new cases coming up. And I don't see indictments. Are there indictments already?
Your Honor, there are 3 P files and they're still unindicted.
Okay. Ms. Swineri, if you will check the status of those. I see our motion to revoke was filed as of February. So, Mr. Montes, you are appointed, right? Are you appointed on those new cases?
Yes.
Okay. So as soon as they come over to our court, what I will do is I will set this for another 30 days out for a probation status hearing. If we don't have those new cases yet, we'll follow up with the state on that. And then your probation case will pretty much track your new cases. If you need me to consider bonds or anything like that, please feel free to file a motion. I will say though, when I saw the bench warrant, I did review the underlying cases. You know, I don't think is there a probation report on her, Carla? There probably is.
Yes, Your Honor.
What is probation's recommendation?
It is for the case to be screened for BHRTC, Your Honor.
Yes. Mr. Montes, if the underlying cases, you know, have any weight, I think it's very unlikely we're keeping her on probation. Okay.
Thank you, Your Honor.
Thank you very much.
May I be
Right. Yes, sir. Thank you.
Thank you.
Who's next?
Kareem Hamed. Annex, can we have Kareem Hamed?
Yeah.
Mr. Rivas?
Thank you, Annex. Go ahead, Mr. Monares.
Calling cause number 2024-0D-00823 and 2024-0D-01361, all style state of Texas versus Ahmed Karim. May I have announcements, please?
Ada Waneri for the state of Texas, present ready.
Good afternoon, Judge. Jesus Soles on behalf of Mr. Ahmed Karim. Judge, it appears she's got a brand new case that's not on your list, 2024-0D-02239. I think that one was recently indicted. It's a theft.
What is that one? Thank you for that.
Theft of property under $2,500 with 2 or more previous convictions.
Okay, we need to add that one. 2024-0D-02239.
Correct.
Had you filed, well, I'm fine with, I think that one has a 10,000 cash surety bond. Thank you, Mr. Olivas. You may proceed.
Thank you, Your Honor. Judge, my client is a young man of 31 years of age. He is a resident alien, originally from Lagos, Nigeria. He's had a resident status since 2017. He works as a technician, fixing smart meters, electrical stuff. He also works at warehouses and auto tech and delivery. His wife lives in New York. They're separated. They have no children. He's been in El Paso approximately 7 months. He did not, at the time I spoke to the time back, he did not have a home or telephone. That may have changed since then, though. If I could ask him, Judge?
Yes.
Mr. Karim, good afternoon.
Good afternoon.
Sir, are you still homeless?
Yes, Your Honor.
How about a telephone number?
No, I don't have a telephone number.
I know you had an email address. What is that again?
hkarimforreal@gmail.com.
That's all I have, Your Honor.
Okay, Ms. Waneri?
Your Honor, state would oppose any sort of bond reduction. The defendant has only been in town for 7 months and has already picked up 4 or 5 cases, most of them consisting of theft of property from the citizens of El Paso. Clearly, he is a danger to the citizenship here, and we would ask that this bond remain the same. On top of that, even if he were to be given a bond of any sort, there'd be no way to contact him because he doesn't have a telephone number or a permanent address. All he has is an email address, which can easily be overlooked in terms of communication. So the state would ask that the bond remain the same.
What's the alleged date of offense on that theft case, the 2239 case? Is it March 26th?
It is March 26, 2024.
So 3 months, 3 offenses allegedly.
Yes.
All right. Mr. Olivas,
Yes, ma'am.
anything else?
That's all I had, Your Honor. Thank you.
Okay, your request is respectfully denied. Thank you very much.
Thank you, Judge. May I be excused?
You may. Thank you, Mr. Karim. Who's next?
Annex, can we have Jennifer Marquez, please?
Ms. Matney, is that yours?
Yes, Your Honor.
Okay. Ms. Marquez, are you there?
Yes.
Okay. Mr. Dunham, you ready?
Yes, Your Honor. Yes,
Right,
Your
go
Honor.
ahead and call him, Mr. Monares.
Calling cause number 2021-0D-02208, 2018-0D-01848, 2023-0D-07956, and 2020-0D-02725, all style state of Texas versus Jennifer Marquez. May I have announcements, please?
Good afternoon, Your Honor. Erin Delaney Matney for the state on 1 case only, Your Honor.
Okay. Which case is that? And then who is covering the others?
Yeah, I think the other cases were going to be covered by Ms. Waneri.
Okay.
And my case is the 2020 0D02725.
Okay. So let's start then with cause numbers ending 7956 and 2208. Ms. Marquez, for your reference, those two cases are the two new cases, not your probation cases, okay? Ms. Marquez, I can't hear you. I don't know if the camera's at a weird angle.
Yeah, okay, I understand.
I hear you now. Maybe it was just a bad connection. All right, Mr. Dunham, you're ready?
Yes, Your Honor.
Ms. Marquez, I did receive paperwork on all of these cases. In terms of the two new cases, I have documents indicating your intent to plead guilty. Is that your understanding of what you're doing here?
Yes, ma'am.
And I believe on this one, we did receive all of the written consents for conducting the plea remotely. Is that correct?
Yes, ma'am.
Okay, and so Ms. Marquez, you're in agreement to do this over Zoom?
Yes, ma'am.
Okay, in order to get started with your plea, I need to swear you in. Ma'am, would you raise your right hand, please? Do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, ma'am.
Thank you very much. You can put your hand down and state your name and date of birth for the record.
Jennifer Marquez Alcala, May 26, 1981.
Ms. Marquez, as I mentioned, I received documents from your attorney in each case. The first document is marked as State's Exhibit number 1. Those are the plea papers. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Ms. Marquez, do you recall reviewing State's Exhibit number 1 with your attorney before you signed that document?
Yes, ma'am.
And did you understand everything contained within that document?
Yes, ma'am.
Mr. Dunham, have you had more than 10 days to prepare a defense in each of these cases?
Yes, I have, Your Honor.
And did you explain the plea papers to your client?
Yes, I did, Your Honor.
Do you believe she has understood the admonishments, rights, and consequences of giving up these rights by entering her pleas today?
I do, Your Honor.
Ms. Marquez, are you satisfied with your attorney's representation of you?
Yes, ma'am.
Mr. Dunham, any reason to believe your client is not presently competent to enter her pleas?
No, Your Honor.
Ms. Marquez, have you ever been found mentally incompetent by any court?
No, ma'am.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, ma'am.
So based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your pleas. Ma'am, are you a U.S. citizen?
Yes, ma'am.
Where were you born?
Santa Ana, California.
Okay, in cause number ending 2208, you are charged with the first-degree felony of manufacture or delivery of a controlled substance in penalty group 1 in an amount between 4 and 200 grams. To that charge, ma'am, what is your plea? Guilty or not guilty?
Guilty.
In cause number 2023-0D07956, you were charged with the state jail felony offense of manufacture or delivery of a controlled substance in penalty group 1 in an amount less than 1 gram. To that charge, ma'am, what is your plea? Guilty or not guilty?
Guilty.
Are you making each of your pleas freely and voluntarily?
Yes.
I will find you are making your pleas freely and voluntarily. Ms. Winery, would you summarize the evidence, please?
Your Honor, in cause number ending in 2208, had the state proceeded to trial, the state would prove beyond a reasonable doubt that on or about the 4th day of July 2021 in the county of El Paso, state of Texas, Jennifer Marquez did then and there knowingly possess with intent to deliver a controlled substance, namely methamphetamine, including adulterants and dilutants in an amount of 4 grams or more, but less than 200 grams. As such, she has entered into a plea agreement with the state of Texas for 5 years in the Texas Department of Criminal Justice. The state would submit states 1, the plea agreement, states 2, the trial court certification, waiver of appeal, states 3, the 3914 discovery certification.
Any objection?
No objection. No objections, Your Honor.
State's exhibits in that case are admitted.
Your Honor, in cause number 20230D07956, the state will move to dismiss.
I have that down as a plea to 8 months state jail felony. That's what the paperwork said. Is
Your
that
Honor,
changed?
the labs have not come in, and I don't feel comfortable pleading her to a case where the labs haven't been turned in.
All right. So.
No objections, Your Honor.
Well, I wouldn't imagine. All right. In that case, Ms. Marquez, I believe I asked for a plea in that case. The state is telling, and you have entered a plea of guilty. The state is saying they are going to dismiss that case at the time they do not have the lab reports. Okay, so the court will not be accepting your plea of guilty in that case. And once I receive a dismissal, I will sign it.
Thank you.
All right. Okay, with respect to cause number 2208, Mr. Dunham, is that your understanding of the plea agreement?
Yes, Your Honor.
And Ms. Marquez, is that your understanding as well?
Yes, ma'am.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page document entitled The Trial Court Certification of Your Right to Appeal. It's a document that explains your appeal rights. Because this is a plea, bargained, or negotiated case, you do not have an automatic right of appeal. Ms. Marquez, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, ma'am.
Was signed by your attorney and signed by the court as well. So on your plea of guilty and the evidence introduced, I will accept your plea and at this time find the evidence substantiates your guilt. I will find you guilty of manufacture or delivery of a controlled substance in penalty group 1 in an amount between 4 and 200 grams. And I will sentence you according to the plea agreement to 5 years confinement in the Texas Department of Criminal Justice Institutional Division. You will receive credit for any and all time that you have served, and it will run concurrent with any revocation or in your probation cases, okay? So Ms. Winery, if you'll just get me the dismissal on that case, and I guess Ms. Welch, if you have that plea paperwork, make sure we get rid of that. All right, now as to the 2 probation cases, cause numbers ending 1848 and 2725. Ma'am, Ms. Marquez, I will remind you, you're still under oath. Let's see, in cause number 2018-0D01848, ma'am, are you the same individual who on July 26, 2018, pled guilty to possession of a controlled substance in penalty group 1 in an amount between 1 and 4 grams, and you were placed on deferred adjudication probation for a period of 4 years? Are you that same individual?
Yes, ma'am.
And in cause number 2020-0D02725, are you the same individual who on December 8, 2020, pled guilty and was found guilty as to counts 1 and 2 in this case? Count 1 being fraudulent use or possession of identifying information, more than 50 items. Count 2, forgery of a government or national instrument, money or security document. Are you that same individual?
Yes, ma'am.
And in that case, you were placed on 10 years community supervision. Is that right?
Yes, ma'am.
And you were explained all of the terms and conditions of your probation for each of these cases?
Yes, ma'am.
Mr. Dunham, do you waive formal reading of the motions in each of these cases?
Yes, Your Honor.
Okay, Ms. Marquez, I have documents for each of these cases marked as States Exhibits 1, 2, and 3. Those are the stipulations and waivers for each probation case. Did you review those with your attorney before you signed them?
Yes, ma'am.
Did you read and understand everything contained within those documents?
Yes, ma'am.
Are you freely and voluntarily waiving the rights explained in the documents that you signed?
Yes, ma'am.
And do you understand that by signing those documents, you're giving up certain constitutional rights?
Yes, ma'am.
You understand that you're making a judicial confession in each of those cases?
Yes, ma'am.
You understand that on a plea of true and all reasonable probability, I will find the allegations in each of the state's motions to be true. And in your deferred case, I will adjudicate you guilty. And then in your straight probation case, find that you have violated your probation and revoke your probation. Do you understand that?
Yes, ma'am.
With regard to each of the motions in these cases, do you wish to enter pleas of true or not true?
True.
And that's as to both cases, ma'am?
Yes, ma'am.
Okay, and I understand, well, why don't you all just tell me what the plea agreement is? Is it the 5 years TDC?
Yes, Your Honor, 5 years.
Okay, Mr. Dunham, is that your understanding of the plea agreement?
Yes, it is, Your Honor.
Ms. Marquez, that's your understanding as well?
Yes, ma'am.
I will accept that plea agreement and admit all of the state's exhibits in each of the probation cases. Court will take judicial notice of all the documents in each of the district clerk's file for these two cases. Ma'am, based on the evidence presented here today and on your pleas of true, I will find that there is sufficient evidence to support all of the allegations in each of the state's motions. In cause number 1848, I will find you guilty now of possession of a controlled substance in penalty group 1 in an amount between 1 and 4 grams. And I will find that the allegations in cause number 2725 are true, and I hereby revoke your probation there. As to each of these cases, the judgments are amended to 5 years confinement in the Texas Department of Criminal Justice Institutional Division. That will run concurrent with your plea in cause number 2021 0D02208. Is there anything further, Ms. Matney, Ms. Waneri?
No, Your Honor.
From the state, Your Honor, no.
Mr. Dunham?
Your Honor, just to clarify that she will receive credit for all time served.
Yes, sir.
Thank you, Your Honor.
Alrighty, there's nothing further. Good luck to you, Ms. Marquez.
Thank you, ma'am.
Thank you, Your Honor.
You're welcome. Who's next?
That's all I have. May I be excused?
You may have a good day.
Thank you, Your Honor. You too.
Who's next?
Page 18, Judge Reyes Armando for Mr. Esper. Annex, can we have Reyes Armando, please?
Coming out.
Good afternoon, Judge.
Good afternoon, Mr. Esper.
How are you?
I'm all right. How are you?
Surviving.
That's good. That's good enough.
Yep.
Let me see, Armando Reyes. All right, go ahead and call it, Mr. Monadas.
Calling cause number 2024 0D00687 and 2022 0D04169, all style state of Texas versus Armando Alonso Reyes. May I have announcements, please?
Jacob Reynolds for the state of Texas, ready to proceed, Your Honor.
Richard Esper on behalf of Mr. Reyes, ready to proceed, Your Honor.
And Mr. Reyes is appearing remotely from the jail annex. We are scheduled. Is it just a status conference? Let me see.
Yes, Your Honor.
Status, probation. Okay, so how are we doing on this case? The 2024 case, it looks like that's a state jail. Okay.
Your
Looks
Honor,
like that's 5 years on the probation case last time, but where are we?
on the status, Your Honor, you said that you were inclined, based on probation's report, to put him back on probation, but you wanted to hold him accountable for the 3 months he didn't report, and I think he's already done that time. The state wanted to go forward on the unauthorized use of the vehicle, and we're recommending 5 years incarceration, of which we're not in agreement to.
Let me ask on that unauthorized use, is this the one that it was the girlfriend's vehicle,
Correct.
church's chicken? Okay.
Correct.
Okay. It is I do see the recommendation here on the updated case summary to place him onto the forged caseload, modify his probation that way. State
What caseload? I'm sorry.
fortitude, opportunity. It was new, I think, last time too, or maybe 2 settings ago. As Carla and I both learned something.
Okay.
It is a specific type of program, I think, that is meant to give him some of that moral recognition therapy treatment tools that will hopefully make him successful on probation. Mr. Reynolds, you have both of these cases?
Yes, Your Honor, and I'm working with ADA Nwaneri on both our motion and the new case.
And I just sent her an affidavit of non-pros from the complaining witness.
On the vehicle case?
Yes.
Okay.
And Your Honor, I mean, Mr. Reyes also has an outstanding, it's a misdemeanor, but it is an evading arrest or detention.
The recommend on that was time served.
But Your Honor, I bring that up to point out that I would say that is evidence more than anything of Mr. Reyes's should I say his approach to complying with even the minimum requirements of complying with law enforcement. It seems to me that between that and his conduct while on probation, and the fact that he also evaded arrest or detention with the vehicle as one of the counts that he's currently on probation on, he is not a good candidate for probation, and the state would stress that to the court.
So I'm looking at his priors. Let me make sure I'm looking at the right person.
The alien smuggling, Judge.
Yeah, so what happened with those cases?
Pled guilty.
Hold on a second, hold on. Yes,
gave him
those are the
probation.
ones we have. So we have these, and then he picks up the unauthorized use, and then
Correct.
he picked up the evading. Miss Carla, what do you have for me? Anything besides the case summary?
Nothing, Your Honor. It is my understanding that besides, also, if the court were to grant Mr. Reyes to attend and be modified into the forged caseload, he would also be attending TAP, as he was already attending TAP, so he would continue TAP, be modified under forged caseload, and be enrolled to complete the MRT program as well, the counseling.
So does he want to do that, Mr. Esper?
He indicates to me he does, Your Honor. And I've already admonished him that his probation this time around is going to be a lot more difficult than it was the first time. And that this was his last bite out of the apple if the court were to grant him probation. So I think he maybe gets the picture. I hope he does.
All right. I am, where is he going to live? Does he have a place to live?
He's back with the girlfriend again, which is a stable home for him. She has a child. She's being supported by her sister because she's going to school as well, who is a licensed nurse, works for Las Palmas, I believe. And so there's an environment there. I think the issue that concerns me is he's got two younger siblings whose mother has basically abandoned him, last I heard, and she had a serious drug issue. So that's a heavy burden for him to carry, but I think he's willing to do that.
Okay, so I hear what you all are saying, Mr. Reynolds. I hear what you're saying. The court is comfortable modifying him on his probation to this more specialized caseload. We still have the new case to look through. He's set for trial in December, unauthorized use. What I am going to modify him to that caseload. I am also going to include a no offensive contact. That'll be part of his terms and conditions with the complainant in the, the girlfriend.
But he lives with her, Judge.
I understand, but he's not going to have any offensive contact with her.
Okay.
I mean, if I remember from the report on the unauthorized use, there was some
okay.
that was not very nice.
I get you.
So what I mean to say, Mr. Reyes, you're hearing the state. The state doesn't want to leave you on probation. They want to go after you and put you in prison. Probation has coming to me with a recommendation that if you go through this more intensive probation, you're going to fix some of these problems, right?
Yes, Your Honor.
And I'm saying that I'm willing to work with you on that. I don't know what the state's going to do on the new case, but a lot of what's going to happen is we're going to find out if you really want to change your ways or not. And once you get squared away with probation on all these new things, you're going to be subject to all kinds of stuff. You're still testing no offensive contact with the complainant. I don't know what her name is, but that'll be part of your new conditions. And, I say this over and over again. It's not really my concern what the behaviors are of other people. It's you. And so you're either compliant or you're not. And believe me, I'm going to remember how much Mr. Reynolds was sitting here telling me he's not meant to be on probation, Judge, because he can't follow rules. Because if you don't follow the conditions of your probation and you are back in the position that you are right now, what is Mr. Reynolds going to tell me? I told you so, Judge. Right?
Yes, Your Honor.
And do you think you're going to get out again?
No, Your Honor.
No, you're not. All right. Get me the modifications, Ms. Pineda.
Your Honor, on the unauthorized use, can the court release him on a PR bond until
What is the bond?
I'm not sure yet. I don't have it in front of me.
And Judge, if the court is intending to place him back on the Forge caseload, the state would respectfully request that he be placed under the intensive supervision if that's not already included in the order.
On the probation?
Yes, Judge. And if he's on PR bond, that he be placed on the intensive
Reporting.
reporting.
Your Honor, if I may, on the probation case for Mr. Reynolds, yes, that would be part of special programs already, intensive.
Okay.
Well, I mean, we're kind of, you know, jumping ahead. We were only set for a status on the new case. He's got what? A $5,000, is that right? Is it a $5,000 cash surety bond on the 0687? Miss Jasmine, can you confirm for me? Or is it 100,000?
Sorry, Judge. Give me a minute, please. Odyssey's acting up, but I will confirm in a bit.
Your Honor.
Yes, ma'am.
While we await from Ms. Welch, may I, on the record, address Mr. Reyes? Just
Yes,
to
ma'am.
remind him if he is released to report.
Do you hear that, Mr. Reyes?
Yes, Your Honor.
You have to report immediately if you are released.
Yes, I will. I'll go straight to the probation officer.
Yes, Mr. Reyes, so make sure to go to the Isleta office where you were reporting before.
Yes.
If you remember the name, that's fine. Her name, your officer is Beatriz Magaña. If you don't remember, you can always it's at the office, the Isleta office where you were reporting, and just ask to see your probation officer as soon as you get released.
Yes.
Monday through Friday, between 8 and 5 p.m., please.
Yes.
Judge,
Look, Mr. Reyes, on your motion here, the motion to revoke, you know, you also didn't report for July to September.
Those are the 3 months, Your Honor, that we're going to hold him accountable for. And he's been in for over 3 months, I believe.
All right.
And on the misdemeanor, on the evading, we're set for a final hearing tomorrow, so I can get that disposed of, I'm sure as well.
Okay.
But I just needed the bond changed to a PR bond,
I am
if possible.
I am hesitant to ask this question. We are not set for a bond hearing on the unauthorized use case. So Mr. Reynolds, you're obviously entitled to 3 days.
Judge, if he's being modified on the probation and released on PR bond, we'll waive our 3 days.
Thank you, sir.
Okay. So in terms of the bond then in 2024 0D00687, I will grant that a $5,000 PR bond. He is to comply with all his conditions of probation in cause number 2022 0D04169. And usually that subsumes all of the conditions we normally add. So no new offenses, curfew, all of those things, the no offensive contact, all of those are conditions of the bond in your new case. I understand you have a misdemeanor case, Mr. Esper. I think that's a $1,000 cash surety bond. He's going to go work on your misdemeanor. What all of that means to say, Mr. Reyes, is that, again, you don't follow the rules, you don't follow the conditions, everything gets pulled and you're back in jail. Okay?
Yes, Your Honor.
All righty. Anything else?
Your Honor,
Monday.
just to remind the court, I wasn't sure if you had seen it on the summary, but back in October, he did test positive for marijuana, and therefore that's the reason he was referred to TAP.
Okay, can't be doing that, plain and simple. It's a violation of your bond conditions, violation of probation. They catch you with it, they catch you doing it, it's a new charge. So there you go. You're either gonna keep racking up cases that are gonna keep you in jail, or you're gonna stop. So thank you, Miss Carla. All right.
Thank you, Your Honor.
Thank you very much.
May I be excused?
Let me make sure he has everything He has a trial track and he has, we need to make sure and carry the probation case with it.
Okay.
Okay, alrighty, thank you very much.
Thank you, Your Honor.
Mhm.
Judge, may I have excuse as well, please?
Yes,
Thank you.
thank you. Who's next? Thank you, Mr. Reyes.
Thank you.
Page 15, Judge, Jacqueline Guzman. Annex, can we have Jacqueline Guzman, please? Mr. Hoffman?
All right. Ms. Vallejo, are you on this one?
No, Your Honor, it's me, Alejandra Navarrete.
Oh, sorry. Okay. Sorry.
Sorry.
Don't be tricky. Don't trick me like that.
I didn't want to go run into the technical difficulties that we did last time, so.
Okay. Go ahead and call it, Mr. Monares.
Calling cause number 2018-0D-05777, State of Texas versus Jacqueline Guzman. May I have announcements, please?
Ada Winary for the state of Texas, present ready.
Rick Huffman, on behalf of Ms. Guzman, we're ready.
Alejandra Navarrete with adult probation, Your Honor.
And Ms. Guzman is appearing remotely from the jail annex. I thought we were just kind of checking time giving time so you could discuss the safe P option. I believe I did see the case summary, or Ms. Navarrete did explain some things, or at least have some type of conversation, but Ms. Guzman was going to come back to you, Mr. Huffman. So what are we doing? 2 TDC or safe P?
You know, Judge, I did not realize that those were the only two options we had. A little background, Your Honors. Miss Guzman has been on probation for it's a possession over a gram and a tampering case. So not the most, egregious cases. And Your Honor, she is dealing with some serious mental health issues. The court did gave her a chance at Oliviane, and I just kind of wanted to give some background about what happened. She started hallucinating, Judge. She left Oliviane. She was out. She basically had a mental breakdown at Oliviane, so she left, and she was out on the streets for about 2 days. She found a police officer, and the police officer took her to UBH, and she was in UBH for about 2 weeks, and then she contacted the probation department, who basically transported her to the jail. So that's, she was only out on the streets for about 2 days. She did not like it. She needs help, Judge. She was basically, and Your Honor, I know we've had a lot of issues, and I don't have the answer. She's had some issues with her med compliance, even in the jail. She has not found the right kind of combination of medication. The current meds that she's on make her sleepy and slow, and just the side effects are not good. But I certainly hope that we can find an alternative that doesn't require, I think it's 18 months in a lockdown facility at the safety. Maybe the court can work with her some more. She does have a mom who has good things to say about her, Judge. So she's a really good person, really good girl, young lady, excuse me, and she's always welcome to stay at the house with her mom. But I'm hoping there's some kind
Here's
of.
the thing, though. Here's the thing. Then I need a plan, right? She's already expired, right? February 20th. So we were going to extend her. The recommendation is safe P, because I think of the controlled nature, whether of the treatment. But I mean, we've already gone through all these different placements, Mr. Huffman, and I cannot get her on track. And I understand how complex that is, right? If the nature of it is the mental health angle, I understand that. But I can never get to a point where I have enough compliance that I can say, okay, we got there. I might even just say, you know, we're done, but we have not had that. And so I mean, I don't have a plan. I don't have a plan that I can tailor to ensure at least even 6 months of compliance. You know what I'm saying? I mean, I have no comfort level that, you know, even with resources that we have in kind of maybe an outpatient, maybe maybe another inpatient situation, that we aren't going to have the same result because we've tried that already. And I agree with you 1,000%. Do I think your client is, you know, the most concerning, all those kinds of things, but we have not been able to be at a successful performance by your client, period, with whatever we've done. And I think that's why we were at SafeP. How much time does she have total?
And probation, Your Honor?
No, I mean in jail, because she's been in custody so many times. I haven't gone back and looked to see.
You know, and I'd hate for her to get a pen trip, Judge. But I agree. And will she ever be perfect? I don't think so. But she does have a support system, Your Honor. And I think she does okay. She just does not do well in confined spaces. I think that has creates a lot of anxiety for her. But I understand. I definitely understand the court's concerns. And I just don't have a good answer. I mean, I think she, you know, I think I'm optimistic. I think there is a combination of medication that will work for her in the future. But she just hasn't found that combination yet, Judge.
You know, it's been 5 years that we've been working on this, and she's maintained, right? She's maintained her deferred status.
Correct. And possibly maybe the court can take into consideration the amount of time. Just off the top of on here, not including I think she did about 2 months at Aliviane before she had the episode. She has 83 days here, 86 days here, 59 days here, 20, 66. So considerable amounts of time. Maybe the court can take that into consideration and just discharge her.
What is her mental health regimen right now? I mean, is she stabilized in the jail?
She is not medical compliant right now. I talked to her yesterday. She sounds good, Judge. She sounded good.
But that's not good enough, right? I mean, that's my whole point, is that we don't have a plan. I mean, if you could tell me right now we had her stabilized with meds, you know, then, and I'm not saying this for sure, but I'm just saying, you know, maybe I would consider another stint in an inpatient Aliviane situation with things a little more tailored. We're coming off of jailing where maybe, you know, the meds have got her in a good place and we get a window, right? We get a window of some compliance. But what happened at Aliviane last time was she left. And I understand what you're telling me in terms of, you know, why she left. I get it. But I would have thought we would have had some treatment that was helpful. I mean, if they can, well, but she's not stable. And I was going to say, if they can stabilize her in the jail, how come they can't stabilize her at Aliviane? Is that not their expertise? Are they more substance use? Do they not have sufficient resources to address mental health?
Yeah, I don't know, Your Honor.
Ms. Navarrete, can you tell me a little bit about that?
Yes, Your Honor. Well, I mean, they have of course, she's going through her substance abuse classes, but with Aliviane, they transport them to their appointments for their mental health. They are given their mental health medications while they're in treatment there at Aliviane. So they have the support. They have the what is required for her to continue with her medications and, of course, her appointments in Aliviane.
Ms. Escajeda, were you going to jump on here? You turned on your camera.
Oh, yes, I'm so sorry, Your Honor. I was, just because I'm with the DWI program and we do send clients to Aliviane Residential. So I was going to mention that clients, if they need health network, if they need their services, they do get taken to their appointments. as well as any court hearings that the facility is real good about transporting probationers. I'm so sorry, I didn't mean to jump in.
No, I mean, that's fine. Go ahead.
I don't know if the court would be open to Oliviane, giving her another shot at Oliviane. I don't know if Oliviane will still take her, but certainly that I don't think that would hurt if she got another opportunity.
Ms. Navarrete, what do you think?
I can try and call, Your Honor. The problem that we were having, even after she left Aliviane this last time, what was happening is that even when she was there after a month, she started Aliviane in September. By October, late October, that's when she had her first mental health crisis. So since then, she had been going in and out to UBH to from Aliviane to UBH. So that's why her treatment was taking longer, because they couldn't really focus on the substance abuse because she had to be going in and out to UBH. When on December, when she contracted it, COVID on December, about a week and a half after we had a court hearing, Your Honor, that she couldn't make it because they were on lockdown, Aliviane. That's when she went back to UBH, and from there it was she was back to UBH like 2 to 3 times after that until January, when the last time that she went there to UBH, then she left, and then that she did contact me, Your Honor, but about a week later, after she had left Aliviane.
And I'm sorry, one more thing I wanted to point out. These 2 cases are from October 2018. She has not picked up any new arrests since, with the exception of a theft under $50. I'm sorry, theft under $100, Class C. That's the only offense she's been arrested for. And I think these are before this, there were no prior arrests. So this is all she's got.
Ms. Waneri?
Your Honor, it's always concerning when you have someone who has mental health issues, because in order to address the substance abuse, you have to get them mentally competent, right? So with there not being a real plan to help restore her to a point where she can realize that she has these other issues, it's almost like we're setting her up for failure. If we release her back to the streets, she's going to have, not only the mental health issues, but then the substance issues. So when I hear this, I think, well, is there like a state hospital? Would that be the best place to get her to where her mental health issues will be addressed and she will be put on medication and then compliant with the medication, and then maybe stepped down from the state hospital back to some place like Oliviano where, they will be able to monitor her medication because she's already compliant with it, and then they can address the substance abuse. And then from there, perhaps we put her back, just step her down until she's been compliant with her medication long enough to where it's now more like a habit than like anything else. And then her substance abuse issues have been addressed. That's the only thing I can think, because if we take the shortcut and just say, okay, she's got credit for time served, let's let her out, we'll be picking her body up off the streets. Like, that's what's going to happen. So maybe if we can talk to some sort of state hospital and see if that is something that they can do, and then just step her down until she's compliant and she takes her medication without force.
Ms. Navarrete?
I think, Your Honor, she does need a lot of help, Your Honor, and I think we could definitely help her. I just think that with being safety, she'll have that substance abuse help there, as well as the mental health, the EHN. She can be at a more controlled environment. I really think that she can benefit from being in safety.
Mr. Huffman, I think we've just we went backwards and we rehashed everything and we're back. I'm at SafeP. If she wants to keep that deferred status, and I'm not saying I'm not psyched about her not keeping her deferred status. You know what I mean? I get you on that, but we are not at a point where I can go backwards because I don't have any confidence that she'll be successful, because she's not there right now. So it's SafeP. That's it. I mean, that's it. I don't want to have to go back again and do this.
Maybe we could come back and bring her mom. She does have access to mental health treatment, Judge. It's just, we can, I can't force her. The court can't really hold her hand. I mean, she's going to have to do that herself, but she does have access to those programs and that treatment. So the tools are there.
Whether she has access, it has not proven to be useful for 5 years.
And Your Honor, I definitely believe she's competent, so I don't think, a state hospital.
Yeah, we're doing safe P. If she's not in agreement, then she can do time and take a conviction. You make that decision, 2 weeks.
Okay.
I don't want to
Thank
do this again. We keep coming
understand.
back. All right,
Thank you.
thank you very much. Okay,
May I be excused?
thank you for your assistance.
Thank you.
Who's next?
Next one is on page 17, Judge Morales Ricardo.
Go ahead and call it. Annex,
Oh.
if we could have Ricardo Morales.
Calling cause number 2020 0D02544, State of Texas versus Ricardo Morales. May I have announcements, please?
Ada Winner for the state of Texas, present ready.
He also has case number 2023 0D04923. Also State of Texas versus Ricardo Morales.
Ada Winner for the state of Texas, present ready.
Rick Huffman on behalf of Mr. Morales.
Is that your client, Mr. Huffman,
Yes,
appearing from the annex?
that's him, Your Honor.
Okay, we're set for bond hearings. I show 40,000 on cause number 2544 and 20,000 on cause number 4923. You may proceed.
Your Honor, we are respectfully requesting the court consider reducing the amount of the bond. Currently, the $60,000 bond, the total, is too high for Mr. Morales to pay. The reason we're asking for a bond is so that he can bond out of jail, Judge. He is a United States citizen. He is a mechanic. He works at Cifuentes Garage in Fabens. Judge, he has a 10-month-old, a 2.5-year-old child. His girlfriend wants him out. She's the complaining witness. She's been his girlfriend for about 4 or 5 years, and she has, aside from their 2 kids, she has 3 children of her own, and she needs his help. She has signed a non-pros in the new allegations. The non-pros does state that Mr. Morales did not assault anybody. Your Honor, the big problem we had, Mr. Morales was in the DWI court. He finished the DWI court, and after he finished, he didn't know where to go. The probation department didn't really segue him into a new kind of probation, and he relapsed. He is an alcoholic, he did relapse. But Judge, we're hoping that he could get another chance on to show the court that he's going to stay sober. That's always been the problem here. There were no serious injuries in this case. And Judge, he's denying the allegations, and so is the complaining witness. So we're asking court to consider reducing the bond, Your Honor, so that he can bond out and basically help and prepare his defense and show the court that he can be successful on probation.
All right. Ms. Winery?
Your Honor, the state would oppose the reduction of the bond. Mr. Morales has a history of violence, including injury to a child, elderly, or disabled. He was convicted of 2 counts of that. Assault causes bodily injury to a family member. He was convicted of that. He was convicted of, he's on deferred for assault, family, household member, previous conviction, driving while intoxicated. He has 2 of those. No, Your Honor, the state believes that not only is he a danger to the citizens of El Paso, based on statements from defense that he is an alcoholic, he has a propensity to drive when he drinks, and he also is violent towards those who, I guess, anger him and those who he lives with. We feel like the bond is adequate, and that even with an affidavit of non-prosecution, the state would go forward with their charges.
And Judge, that if I can respond.
Yes, sir.
My comment on him being alcoholic, he was in the DWI court, and then he was left with nothing. And I think that that was kind of an unfair situation to place Mr. Morales in a situation where he gets this intense treatment and then goes to nothing.
Your Honor, if I may. So Mr. Morales was with the DWI program. I was transferring his case to regular supervision before it was noted that he was supposed to, excuse me, complete the domestic violence case. So of course, because we concentrated on his DWI case and the conditions for the DWI, I asked that he complete his BIP class. I asked that he complete other conditions for this case before I transfer the case. I gave him guidance in that, and he neglected to do so. It was very hard to get a hold of him. It was always through telephone. I was trying to get a hold of him. He was sent to drug tests several times, did not, always changing the, excuse me, his telephone number. There was one time where I looked up the number to the Cifuentes garage, and when I asked for him, they hung up on me. I can't get those exact dates for you, Your Honor. I'm sorry. When the request for the bench warrant was submitted, I believe there was a mistake on the conditions. So they redid the case and I couldn't see on my chronos to give you those exact dates. But I did attempt to help Mr. Morales. If he continues on probation, Your Honor, he is accepted into the domestic violence caseload if the court sees fit that he go into a more intense supervision.
Mhm.
And it was on his original conditions. Excuse me, Your Honor.
When did he finish the DWI court portion of his probation?
Let me look that
up. Let me, I mean, we're kind of delving into bigger picture here. Let me address the bond. Do you have anything else on the bond, Mr. Huffman?
Well, Judge, he's been in jail for 159 days on a $60,000 bond, which you can't make. So we're hoping the court just consider just maybe cut it in half, Ron.
Is there anything that he can afford?
He can't afford the 60,000. I mean, I'm thinking 1,000, but I you know,
that's not gonna happen. No, I did consider ask your attorney, Mr. Huffman.
What can you afford, Mr. Morales? What kind of bond?
Right now I'm having some financial problems. My wife is currently working right now, but she's struggling to keep ends meet regarding the bills and the rent. She had to be paying a babysitter so she could go to work, and literally yesterday they cut off her light, so I had to call one of my aunts to let us borrow the money so he could reopen the light. So right now I don't have the money.
Okay. Thank you, sir.
Anything else?
Your Honor, to answer your question, it was June 2nd of 22.
And I mean, I considered we had a bond hearing, right, in January, and I reduced the probation case to 40,000. And the new case, I think, is adequately set. So on that, no, your request is respectfully denied. The bonds will remain the same. We're set for trial in June, so you know we're a little over a month out. What is the did I already ask this? What's the rec?
No, Your Honor. The rec on 2544 is an old rec, which I will be changing. So right now,
I really want to know what's 4923. What is that looking like?
give me one moment.
I mean, Judge, we would hope to maybe modify his probation and straight probation, plead to the new cases, make him a convicted felon, and let him take the BIP classes and get to work. That's what we're hoping for.
The last rec was 3 TDC, which he declined.
Does he have a prior pen trips?
No, actually, I didn't see any. I looked at his rap sheet.
I didn't notate any. I did review the PSR, but what stuck out at me was mostly picking up the new case. I can't say I'm terribly averse to what Mr. Huffman has just mentioned, Ms. Winery, but you know the 2023 case better than I do. If the complainant and the state is, I don't know if you're married to TDC or not.
I mean, it would have to be a very compelling reason as to why he wouldn't go. And, you know, if it appears that he's been given every opportunity to avoid prison, and he hasn't taken any of that seriously. So
yeah, I'm not a real fan of coming over here and saying, well, you know, I was doing so well in DWI court and then they just let me go. That's not owning up to your responsibility, Mr. Morales. So, yeah, well, we're here for the bond hearing. Denied. Your next setting is the final hearing plea deadline. I'll let you all talk about that. Thank you very much. Thank you, Ms. Escajeda. All right. Do we have anything else?
Yes, ma'am. Annex, can we have Melissa Segura?
Yes.
Calling cause number 2022-0D-01966, State of Texas versus Melissa Segura. May I have announcements, please?
Ada Winery for the state of Texas, present, ready.
Rick Huffman on behalf of Ms. Segura, we're ready.
And Ms. Segura is appearing remotely from the jail annex. I think this is one we have had outstanding. She was booked March 7th. We're set for a bond hearing. We had a PRKPS back in March of 2023. She failed to appear for a final hearing plea deadline, failed to comply with some mental health treatment. She's at $100,000 bond. Looks like there's a couple of thefts and she should have some outstanding warrants out of CCR2. Doña Ana, 2021, credit card theft, but no new cases here. So her bond is 100,000. You may proceed, Mr. Huffman.
Thank you, Judge. Just give me one moment, please. Your Honor, we are respectfully requesting the court consider modifying her bond to something that she could afford to pay. And her current financial status is pretty bad. She is currently not working. She hasn't worked in a while, and she is making $600 from SSI. She does live here in El Paso. She is a U.S. citizen. She's a graduate of Bel Air High School. Your Honor, this is an old case. The case deals with what I consider a misunderstanding. It's a burglary of habitation. She was under the impression from her fiance, Miss Melissa Maldonado, who has pled guilty to the same incident and is currently on probation, has a warrant, all that, but they are no longer involved. But anyway, Miss Maldonado, the co-defendant, basically hired my client, and they basically, from what my client understood, were hired to clean this house out. That was what my client understood the situation to be, and I think that that there's evidence of that. A neighbor came up to them. Miss Segura gave the neighbor her information, her driver's license. She thought everything was on the up and up. So the recommendation was probation. It may still be, I don't know. Now, since Miss Segura has been in custody, she has been basically strongly considering taking the probation deal. just so that she can get out of jail. So I wanted to set this bond hearing and allow her to evaluate the case without basically jumping to the conclusion to plea. I don't believe she has any felony convictions. I may be wrong on that from Doña County, but that's my understanding. Judge, she does have some mental health issues. She is receiving medications in the jail, but she has had to ask for lockdown, basically solitary, because she gets such severe anxiety in the jail. The main reason, Your Honor, we are asking for a bond reduction is because about a year ago, Ms. Segura was diagnosed with multiple sclerosis. That condition is very painful, and she is getting treated outside of the jail for that. I think in the jail she's getting like Tylenol or something to treat that. So that's a very obviously serious condition that I don't think is being adequately treated in custody. She does have a place to live. We've confirmed that. She lives with her friend Lauren Franco. We have a phone number for Miss Franco. We have an address. It's 5004 East Yandell. And again, we've spoken to Miss Franco, and she has confirmed that.
Mr. Huffman, she was MIA for a year.
She was.
If I look back and if I ask Mr. Monares to dig back into check-ins from pre-March 2023, I bet you she missed court sometimes there too. I don't know. But she went MIA for a year. And now you're asking me to say, okay, let's let her back out on bond. And I understand what you're telling me, but there's no way. There's no way I'm going to let her out on bond. CCR2 has $30,000 on the 2 cases they have there because she didn't show.
And I think it was a bit confusing to have the 2 courts and the different processes and coupled with her anxiety, Judge. But certainly we definitely understand that yeah, that's why she's been in jail, and I think she's been in jail for what do I have here? It's a good amount of time, Your Honor.
5 days.
But again, I'm hoping that possibly that offer is still on the table. I'm hoping that maybe Miss Winery can take a harder look at that case. But the offer is probation. It's my understanding, Judge. So
Miss
that's why
Winery?
I have taken a deeper look at this case, and it's not exactly as it's being presented. It looks like there was a scheme between the defendant, her then girlfriend, and another gentleman who found out that the victim was moving out of that house, told neighbors that they were there to clean, but instead cleaned out her items, as in they stole her items. So it's not as he's portraying it to be. The offer that was made for deferred, that was made back in 2022. I don't think that she'd be a great candidate for any sort of probation. My offer would be jail time. She has shown us that she can't comply with any rules that we set forth. Like Your Honor said, she disappeared for a year. Before that, I'm sure she was non-compliant. So if left to the state, we would leave the bond as is. And if Mr. Huffman would like her to get out faster, then, maybe we can work this case.
I don't know if you've been able to review this, but was the case, it was at final hearing plea deadline that we lose track of Ms. Segura. So can I understand that to mean that the case is complete otherwise, Mr. Huffman? I don't know if you were on it back in March of 2023. You were? So was it ready to go?
Well,
because she doesn't have any settings, right? We only have the bond hearing. But quite frankly, I'm ready to set her for like June if we're ready to go. Because I'm not going to let her out. Your request for bond reduction is denied.
We would request definitely a speedy trial at that point. But again, maybe we can work something out.
let's get her, Myrna, let's get her a 6-month trial track. So let's see
Okay.
how quickly we can fit her in 6 months.
Possibly, we're hoping to, I think the court may have, did the court ask if we would be okay with the June setting? Because we certainly would.
Well, I say that, but I don't know that the court can accommodate a June setting. That's my problem. But I can certainly get you a setting within 6 months, and we can specially set it. And you all can decide what you have and if there's any way to resolve it outside of a trial. If not, just expect to go.
Thank you, Your Honor, and I'll definitely reach out to Ms. Winery very soon.
Okay, thank you very much. Who's our last one?
Our last one is on page 20, also Judge Stuart Chase.
Okay.
Can we have Stuart Chase annex, please?
This one,
I can tell you he has quite a bit of a PSR history, Mr. Huffman.
Is that like criminal history, Judge?
Yeah, it's basically our wrap, but I show that I don't know that he has ties here. It looks like he's from Michigan. Mr. Stewart, that's you?
yes, ma'am.
Okay, go ahead and call it, Mr. Monares.
Calling cause number 2023-0D-08182, State of Texas versus Chase Bradley Stewart. May I have announcements, please?
Ada Monery for the state of Texas, present ready.
Rick Huffman on behalf of Mr. Stewart, we are ready.
Mr. Stewart is appearing remotely from the jail annex. We are set for a bond hearing. His bond is currently $100,000. Mr. Huffman, you may proceed.
That's correct, Your Honor. The bond is $100,000, which I believe is excessive, and we're respectfully asking the court to reduce that amount. This case is a manufactured delivery possession PG1. It's basically 9.5 grams of meth, Judge. The meth was found in a location that was like, it could have been someone else's meth.
You know what? Let me stop you real quick. I'm just looking. I see that he also has a 2024 case that is recently indicted. Was indicted on April 16th. That is cause number 2024 0D02121. That is a burglary of building. So, and it's $10,000 on that case. Okay, sorry. Go ahead.
Thank you, Judge. That's correct. That bond is $10,000. So the two felony cases, he has a bond totaling $110,000. There's a co-defendant that was also arrested, Judge. Actually, my office, I represent the co-defendant, Franklin White. So I did not get to interview. I felt it was probably better off not to interview Mr. Stewart. I do intend to file a motion to withdraw, but I wanted Mr. Stewart to have a chance for the court to consider reducing the bond. His bond is high right now. Judge, him and Mr. White got arrested for the same substance. They have no way of telling, who the substance belonged to, and both co-defendants denied the substance. It's my understanding, Judge, and I could be wrong because I only have access to the El Paso rap sheet. I do not believe Mr. Stewart has any felony convictions. Could be wrong there. That being said, Judge, we don't have a lot of information. It's my understanding that Mr. Stewart is homeless, but living in the area. Can I just ask some brief questions to Mr. Stewart for the courts to consider?
Yes, Mr. Stewart, raise your right hand. Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, Your Honor.
Thank you very much. Go ahead, Mr. Huffman.
Now, Mr. Stewart, I don't want you to answer too much. I just wanted you to basically pay attention to what my question is and keep it brief. Okay, sir?
Yes, sir.
Are you living in El Paso right now?
Yes, sir.
Do you have an address here in El Paso?
Yes.
What's the address?
My lawyer has the address.
Okay. Do you know the address?
Not by heart. It's my sister's house.
Do you have a phone number for your sister?
Yes.
Could you provide that to the court?
I have it written down, but
Okay.
I'm person.
How long has your sister lived in El Paso?
I think her whole life.
Okay. How long have you been in El Paso?
About 5 years.
Okay. Judge, I've got no further questions.
All right, Ms. Linares, do you have any questions?
I do, Your Honor, just briefly. Mr. Stewart, what's your sister's name?
I don't really know her real name because we haven't been that close for a while. I just now got in touch with her, and she offered me a place to live.
Okay, nothing more from the state, Your Honor.
All right. So in terms of the PSR, Mr. Huffman, I went back because my notes, I can't read them. Looks like he had something dismissed last year in the 243rd and ag. I just wrote ag, so I don't know if that was an ag assault. That was dismissed. But in terms of some prior history, I have Lansing Police Department 2018 burglary. Let me see, breaking and entering, an assault in 2019, assault with a dangerous weapon, 2019 weapons offense is all it says. Taser, possession of a taser. This is in Lansing, and then I guess Ingham County. And then we get to Texas, and yeah, we have a bunch of burglaries, failures to ID, UCW, and there was a notation, some type of FFJ out of Mason, Michigan. There was no more description other than that, so I don't know what that is about. Your request to reduce the bond is respectfully denied. Please, on your 2023 case, I understand you're filing a motion to withdraw. If that's what's happening, please get it filed quickly so we can appoint someone else. And then ultimately what Mr. Stewart can expect is what trial track we get for the 2024 case, considering we're going to get a new attorney. That's going to be the trial track we follow. So for example, he is set in August on the drug case. Okay, we can anticipate that we will follow whatever the 2024 case is. Okay, that's how I'm looking at it right now. But for now, Myrna, let's just get him set up on the 2024 case. And then as soon as we get your motion to withdraw, I'll appoint another attorney for him.
And I'll set up a jail call so I can see if he consents to the withdrawal. That way I can just file the motion with an order.
Sounds good.
I need to okay that with Mr.
Stewart. All right, sounds good. Thank you very much. We do have the 2023 case set for May 21st, so we won't lose track of this one. Okay. All right. Now, is that everyone? Thank you, Mr. Stewart.
Yes, Judge, that's everyone.
All right. Thank you, Annex.
Thank you, Your Honor.
Be safe.